In particular, whereas the first presentation focused on 102A1, this second presentation will introduce paragraph A2 of 35 U.S.C. 102 to include specific examples and special considerations related to 102A2. Determining whether it's appropriate to apply prior art using 35 U.S.C. 102A2 is aided by a three-step process. First, determine whether the reference qualifies as prior art under 35 U.S.C. 102A2. Second, review the application file to determine if any exception under 35 U.S.C. 102B2 applies. Finally, if the reference qualifies and no exception applies, verify whether the reference anticipates the claim language, which means each claim limitation is either explicitly or inherently disclosed. Each United States patent application must include at least one claim which sets forth that which applicant regards as the invention. Each of those claims is a claimed invention. Furthermore, patent applications are filed in the United States Patent and Trademark Office on a certain date. That date is known as the actual filing date for each claimed invention in the application. U.S. patent law also permits applicant, under certain circumstances, to obtain the benefit of or priority to the filing date of an earlier filed application. In those circumstances where applicant has met the requirements for obtaining such a benefit, the date of the earlier filed application will be the effective filing date of the claimed invention. When applicant does not claim or try to get benefit or priority of an earlier filed application, or when the appropriate conditions for the benefit or priority claim have not been met, then the effective filing date of the claimed invention would be the same as the actual filing date of the claimed invention. The statutes that allow applicant to obtain domestic benefit or foreign priority to the filing date of an earlier filed application are 35 U.S.C. sections 119, 120, and 365. Such a benefit claim or priority claim must be made in the application data sheet, or ADS, of the application. Note that the term claim in this particular context is being used here to mean something different than the claims in an application, which set forth that which applicant regards as their invention. In order for the foreign priority date to be treated as the effective filing date during examination, in addition to the claim or request for such priority, a certified copy of the foreign application must be provided, as well as a translation of the application if it is not in English. This is known as perfecting the right of priority. The last thing that is required to actually obtain the foreign filing date is that the claimed invention must be described in that foreign application in the manner set forth in 35 U.S.C. 112A. This means that the foreign application must describe the claimed invention and enable one of skill in the art to make and use the claimed invention. It is the examiner's responsibility to make this determination for each claimed invention. Let's now briefly look at 35 U.S.C. 102A2. Under AIA 102A2, prior art is defined as a U.S. patent, a U.S. patent application publication, PGPub, or an international WIPO published PCT application. The availability of a disclosure as prior art under 102A2 depends on the date the document's subject matter was effectively filed, as compared to the effective filing date of the claimed invention being examined. Please note that WIPO is the World Intellectual Property Organization, and PCT refers to the Patent Cooperation Treaty. An application's foreign priority date can be the effective filing date of a claimed invention. This is unlike the pre-AIA law. The foreign priority date is the effective filing date of the claimed invention if 1. The foreign application supports the claimed invention under 112A, and 2. The applicant has perfected the right of priority by providing a certified copy of the priority application and the translation if the priority application is not in English. You will notice that for both claiming domestic benefit and foreign priority there's a common requirement, which is that the claimed invention must be described in the earlier filed application in the manner set forth in 112A. Because of this requirement, different claims in the same application can have different effective filing dates. This could come about when applicant provides a benefit or priority claim and, for example, the earlier filed application describes and teaches how to make and use the invention claimed in Claim 1, but does not describe or teach how to make or use the invention claimed in Claim 2. In this situation, the effective filing date of Claim 1 would be the filing date of the earlier filed application, but the effective filing date of Claim 2 would be the actual filing date of the application. So the analysis for determining the effective filing date of the claimed invention must be done on a claim-by-claim basis. Remember that AIA status, however, applies to the entire claim set, so that you will never consider Claim 1, for example, under pre-AIA and Claim 2 under AIA. The AIA statutory framework summarizes bases for rejections under AIA 102A1, which was covered in a previous module, as well as 102A2. Note that 102A1 focuses on public availability dates of both patent and non-patent documents, whereas 102A2 focuses on filing dates of patents and other published patent documents. It also covers exceptions under 102B, which will be covered in depth in a later module. For now, note the exceptions to 102A2 under 102B2 include disclosures from the inventor, disclosures by a third party, and commonly owned disclosures. To distinguish between inventor-originated disclosures and non-inventor-originated disclosures, remember the important distinction between another and third party. Examiner training materials use the term third party to refer to someone who discloses subject matter but did not obtain it directly or indirectly from a member of the inventive entity. This is in contrast to another, which refers to someone who disclosed subject matter that was obtained directly or indirectly from one or more members of the inventive entity. Here's the statutory language. Notice that the statute mentions 3 kinds of documents that may be prior art under 102A2. 1. A patent issued under Section 151. 2. A patent application published under Section 122B. And 3. A patent application deemed published under Section 122B. Note that each must name another inventor and must have been effectively filed before the effective filing date of the claimed invention. We will take a look at each kind of document on the next slide. When we refer to U.S. patent documents in the 102A2 training materials, we mean one of these 3 categories. You are familiar with U.S. patents and PG pubs. Further, recall that the international filing date of a WIPO publication that designates the United States is the U.S. filing date of the application. In this sense, WIPO publications that designate the United States are U.S. patent documents. It is important to distinguish between foreign and international documents. The term foreign refers to documents from a national or regional intellectual property office, such as Japan, JP, United Kingdom, GB, or European Patent Office, EPO. The term international is often used interchangeably with WIPO or PCT when referring to documents, and refers to applications filed under the Patent Cooperation Treaty, PCT, and published by the World Intellectual Property Organization, WIPO. International applications may be prior art if deemed published under Section 122B. Foreign patent documents cannot be prior art as of their filing date under 102A2, but may be printed publication prior art under 102A1. This graphic shows examples of documents that are not 102A2 prior art. In these examples, we are considering the applicability of the references in red as prior art under 102A2. In the first two examples, foreign applications are being considered, but they are not U.S. patent documents, so they can never be 102A2 prior art. In the second example, even though there is a U.S. provisional application in the chain, it is still a Japanese application you are considering, which can never be 102A2 prior art. In the third example, the application was never published, so it can never be 102A2 prior art. Certain points should be reiterated and emphasized concerning WIPO-published PCT applications. In order to qualify, a WIPO-published PCT application must have designated the United States in order to be 102A2 prior art. Applications filed on or after January 1, 2004 automatically designate the U.S., but applicants can deselect the U.S., so examiners should ensure designation by checking the front of the document. Under AIA 102A2, there is no requirement that the WIPO-published PCT application was filed on or after November 29, 2000, or was published in English. Under 102A2, a disclosure is not prior art unless the document names another inventor, in other words, a different inventive entity. In this example, both inventive entities are the same, so the U.S. patent document cannot be prior art under 102A2. As shown in the graphic, a reference qualifies as a reference under 102A2 if the U.S. patent document was published and has an effectively filed date that precedes the effective filing date of the claimed invention. Note that it does not matter when the U.S. patent document was published. Note the distinction in usage of the terms effective filing date, abbreviated EFD, and effectively filed date. We use effective filing date when we're talking about an application that is under examination. We use effectively filed date when we're talking about the date of a 102A2 patent document being used as a reference. Examiners must consider the effective filing date of their references and the effectively filed date for 102A2 prior art. 102D explains the effectively filed date of a U.S. patent document being used as a reference, and this slide shows the statutory language in full. The following slides will explain this in more detail. The effectively filed date of a prior art reference is the earlier of 1. The actual filing date of the U.S. patent or the published application, U.S. or WIPO, or 2. The filing date of the earliest application to which the U.S. patent or the published application, U.S. or WIPO, is entitled to claim a right of foreign priority or domestic benefit which describes the subject matter. Again, remember that EFD refers to the application under examination, whereas effectively filed date refers to the prior art date of a 102A2 reference. Remember, 102D is not a basis for rejection. Here are two conditions that must be met to rely upon a domestic benefit or foreign priority date as the effectively filed date. First, the U.S. patent document must claim priority to or benefit of the prior foreign or domestic application. And second, prior foreign or domestic application must describe but need not claim the subject matter being relied upon. Notably, Priority to a prior foreign application need not have been perfected to rely on the effectively filed date of a 102A2 reference in a rejection. Recall that perfecting means a certified copy has been provided, as well as a translation if the application is not in English. This slide addresses how an examiner can obtain a copy of a foreign priority document for purposes of determining whether adequate support exists to use the filing date of the foreign priority document as the effectively filed date of the reference. When a potential 102A2 reference claims priority to a foreign application and the foreign priority date is needed in order for the potential reference to be 102A2 prior art, the examiner should determine whether the foreign application provides support under 35 U.S.C. 112A for the relevant subject matter in the U.S. patent document. Consult STIC for a copy of the foreign application and translation if there's no certified or interim copy of the foreign application in the IFW of the application that issued or published as the U.S. patent document and a translation is not available via the examiner's desktop tools. An example of a desktop tool which may provide translation is a machine translation tool. Even though a U.S. patent document describes the claimed invention in accordance with 102A2, the document may not be used in a prior art rejection if one of the exceptions stated in 102B2 applies. The three exceptions are stated in 102B2A, 102B2B, and 102B2C, and will be covered in depth in a later module. For now, remember that 102B2 exceptions apply only to 102A2 prior art. Also, note there is no one-year grace period involved with 102B2 exceptions. We will preview the 102B 2A exception. Here is the statutory language for that exception only. Under the 102B 2A exception, a 102A2 reference is not prior art as of the effectively filed date if the subject matter disclosed was obtained from one or more members of the inventive entity, either directly or indirectly. Note the similarities between this and 102B1A. Both have to do with disclosures of material that originated with the inventor or joint inventor. Also, the phrase, "the subject matter disclosed," means the same under 102B2A as it did under 102B1A. With 102B2A, however, the disclosure need not be within a grace period in order for the exception to apply. In each timeline, we have an application under examination in which Al, Bob, and Cy are the inventor. In other words, the inventor is collectively Al, Bob, and Cy. Remember, under the AIA, the term inventor means the inventive entity. Each timeline shows a different U.S. published application in blue as a possible 102A2 prior art reference. Those who filed the applications invented the subject matter disclosed. We are considering whether the 102B2A exception applies. If the exception applies, the disclosure is not prior art. In all three timelines, U.S. applications were filed before the EFD of Al, Bob, and Cy's claimed invention, but published after the EFD. In the first illustration, Al is a joint inventor of the application under examination, so the exception under 102B2A applies, and Al's earlier application is not prior art as of its filing date to the invention claimed by Al, Bob, and Cy. In the second illustration, Di is not a joint inventor of the application under examination, but she did obtain the subject matter directly from the inventor. Therefore, the exception under 102B2A applies, and Di's earlier application is not prior art as of its filing date to the invention claimed by Al, Bob, and Cy. In the third illustration, Ed is not a joint inventor of the application under examination, but he did obtain the subject matter indirectly via Fay from a joint inventor, Bob. Therefore, the exception under 102B2A applies, and Ed's earlier application is not prior art as of its filing date to the invention claimed by Al, Bob, and Cy. Remember, for a disclosure to be potential prior art under 102A2, it must have a different inventive entity, that is, it names another inventor. In the examples on the previous slide, the inventors were Al, Bob, and Cy. Because the examiner would not necessarily know how, for example, Di or Ed obtained the subject matter disclosed, the examiner would most likely make a rejection under 102A2, and the exception would become invoked upon receipt of a declaration from the applicant. However, this slide shows two examples of when the examiner should not make a 102A2 rejection because an exception clearly applies based on the existing record. In other words, an examiner should not require a declaration to invoke an exception if 1. The potential prior art disclosure is by one or more joint inventors, but not the entire inventive entity, and does not name anyone else, or 2. The potential prior art disclosure is identified in the application under examination as having been made by, or having originated from, the inventor, i.e. inventive entity, or a joint inventor. To review, there is a three-step process for applying prior art under AIA 35 U.S.C. 102. First, determine whether the reference qualifies as prior art under either 102A1 or 102A2. Next, review the file to determine if any exception under 35 U.S.C. 102B applies. Finally, verify whether the reference anticipates the claim language by ensuring that each limitation of the claim is explicitly or inherently disclosed by the prior art. Remember also, always check the inventive entity. The examiner is reminded that references may be cited to show a universal fact, in which instance they need not be available as prior art before applicant's filing date. Such facts include the characteristics and properties of a material, prior art products, or a scientific truism. Additionally, references that do not qualify as prior art because they postdate the claimed invention may be relied upon to show the level of ordinary skill in the art at or around the effective filing date of the claimed invention. Finally, examiners should check for published or patented family members when an otherwise relevant patent document is found that does not qualify as prior art due to its postdating the claimed invention. Other published or patented family members may predate the claimed invention so that they could be used as prior art. It may be appropriate to use an additional reference as evidence in a 102 rejection in support of the single reference that contains all elements of a claim. Such additional references may be used, for example, to explain the meaning of a term used in the single reference, or to show that a characteristic claimed is inherent in the single reference. Examiners should consult the appropriate MPEP sections for appropriate use of multiple reference 102 rejections and requirements based on inherency. In conclusion, a prior art rejection under any section of 35 U.S.C. 102 is one that can assert that claims lack novelty and are therefore unpatentable. Under 35 U.S.C. 102A2, prior art is applied by 1. Determining if the reference qualifies as prior art under 35 U.S.C. 102A2, 2. Determining whether exceptions apply under 102B2, and 3. Verifying whether the prior art anticipates by explicitly or inherently meeting the claim language.